All right, guys, welcome back to our second training video here. In this one, I guess, we're going to talk a bit about communication and client interviewing. A huge part of what you'll do in our internship is talking to people, working through their stories, identifying what are potential problems and red flags, figuring out what the client's goal is, giving them information and getting information from them. So we're going to go through some general information about what you'll do, terminology, and we'll also talk just a bit about some techniques you may use when you have clients who are a bit reticent to give you the answers that you need. So, the first thing we're going to talk about is the difference between legal advice and legal information. So, legal advice can only be given by attorneys. At least most of you, are not attorneys. So you're not able to give legal advice, but you can give legal information. And we're going to spend a little bit of time here talking about the difference between advice and information, because sometimes that line is a little bit blurrier than you'd think. So let's start with the good news, the stuff you can give. So you can give legal information. All right, what is legal information? Legal information includes general information about the forms or about processes. So if you tell someone a stipulation is a form that is used to change an order when both parties agree about the change, that is just procedural information, right? It is general information about the form. If you tell somebody on this line, you're supposed to calculate what the standardized child support would be. Just explaining the form. That's information. Procedural information is another kind of legal advice. So if you tell someone to file a stipulation, you take it to room 707. That is procedural information. You need to have 3 copies of this document before you take it to your judge's clerk. Procedural information. You can get your arrears balances from room 101. You can get a copy of your proof of service document from room 102. All of that stuff is just information. The last category of sort of information that we can give is very common sense. And I know a lot of you are going to think things that you go, oh, of course, that's very common sense, that aren't. When we're talking about very common sense, we're talking about things like it's not a good idea to call the judge names in your motion, right? So that's something that's very common sense. But if you get someone who's particularly irritated at their court official, they might be like, yeah, I want to say that. Generally, we don't use the forms to talk about, all the times our exes danced naked. I mean, again, there might be times when that's relevant, so we really use lines. We really want to use this carefully, but it is primarily for, you shouldn't say the judge is an evil person that's out to get you, and, you shouldn't use profanity in the motion. Sort of very, very, very common sense. Some of you may say, well, I think it's very common sense for somebody to ask for child support when their ex makes $1,000 a month, and I'm going to tell them they should do that. That is not very common sense, right? We're talking about don't call the judge an asshole kind of stuff. As a general rule of thumb, something is legal information if it would be true no matter who you say it to. So if somebody, the first person comes into the clinic, they're here to do a divorce, and I tell them, you need to do a part 1 with minor children if your spouse gave birth to a child while you were married, even if that child's not yours. That's just procedural information, right? I would say that to anybody who came in. I say it to person A, I say it to person B, I say it to person C. So that is broadly true. Anybody who comes in, no matter what they're here to do, if I tell them a stipulation is used to change an order when both people agree, that's true. Now, if someone came in to do a divorce, they might wonder why I'm telling them that piece of information, but it's just procedural information. So again, if you can say it to any client who comes in and it would still be true, it is probably just legal information. So now looking at the flip side, we have legal advice. So legal advice, as I told you already, is something you guys are not able to give out. Legal advice comes up when you tell someone what they should say or do in their motion. So if you tell somebody you should definitely ask for child support because it sounds like your ex is making a lot of money, you have given them advice. You have told them what you think they should do. And you see, we've got a couple of examples there. You should ask for placement because your ex sounds like a threat. You should try to hold this person in contempt. They sound like a jerk. Again, here you are making a recommendation based on your analysis of the facts of the situation. That's a no-go. That is legal advice. Telling someone what is going to happen in their case. So if you say, yeah, the judge is probably going to order child support because it sounds like you really need it, that is an analysis of what's going to happen. Again, you're analyzing the facts of their case and making a prediction. That is a form of advice. And this one can be really tricky because sometimes clients will sneak it in at the end. They'll kind of be like, so if I ask for support, a judge is probably going to order that, right? And that right is where they're trying to get you to analyze and say yes. And so a lot of you're going to be so focused on your forms, you're going to say, yeah, uh-huh. And what you hear yourself saying is, I'm sorry, I'm trying to focus on the form. But what the client hears is, yes, this is going to work. So make sure you want to be really careful about that. If you ever do have a client that's asking for information you can't give, you can say, unfortunately, I'm not able to give you legal advice, but here's where you can get more information, or but I can ask my supervisor, or but. So make sure that you're not, again, giving people specific analysis of their situation. And I should note here this telling someone what they should say or do in their motion. This gets really tricky because we can tell them what the motion is asking for. So this section wants to know what has changed since your last order, right? This section wants to know, explaining what the section is asking for is just procedural information, right? No matter who I'm showing the form to, that section is asking for the same thing. But a lot of times clients are going to say, well, I don't know how to say it. And then they're going to say something, and they're going to want you to basically craft what they should write there. And you're going to be super tempted to. In fact, some of you, even those of you who are really good at the internship, and you're going to come up to me at some point, and you're going to say, well, what should they say? And it's tricky because we can't tell them what they should say or do. And there are going to be times where that line is going to feel very blurry. So like when a supervisor is saying, you should let them know that generally the court is looking for income information, not information about expenses. It's really hard to see in the beginning. You're going to hear that and you're going to be like, but then why can't I tell this next person what I write? So it can be fairly nuanced, and it can be really difficult to get. So one, it's okay if when you start off you feel like you're not sure, but make sure you are always erring on the side of caution. Make sure you're not telling people what to say, not analyzing their situation. And again, this is just sort of synthesizing our information. Anytime you are synthesizing, analyzing, making a prediction based on the facts of a person's case, right? So you definitely have a substantial change because your ex is in a coma. You should say this because I think it's going to help you win, right? These are where you're analyzing the specifics of someone's case. And again, it won't be true for every person you have who comes in. So if I say, you should definitely ask for child support because your ex is an abusive jerk and it sounds like he makes $10,000 a month, that might be true for person A. But if I say that to the next person who comes in, they're going to be like, what are you talking about? I'm the one that pays child support. Or what are you talking about? My ex isn't abusive. In fact, they're sitting right next to me. We're friends, right? It's only true for that first person. It's not true for the subsequent people I talk to. It doesn't necessarily make sense for them. So if you find yourself in that situation where it wouldn't be true if you said it to another client who came in, then it is most likely legal advice. So again, always err on the side of caution. If you're not sure, it's better not to say something than to say it. You can always check in with the supervisors and we can determine it may be something that you're able to say. But also keep in mind, all of the supervisors are attorneys. So if there really is something that desperately needs to be said, we can give that advice. We can come over and say, here is my advice. I think you should do this or that. But it needs to be coming from us, not from you. Because again, only lawyers can give legal advice. If those of you who are not attorneys give legal advice, it is called practicing law without a license, and it's not something that we want to do. Just some quick examples of legal advice versus legal information. So we're going to go through these real quick, and then we'll have sort of an answer key. If I say, in a divorce case, the summons and petition need to be served on the other party within 90 days, right? 90 days from the day you filed your case was June 10th. Today is August 19th. You're toast, dude. If you have the food share up on your phone, we can approve the fee waiver down here. Everyone has to fill out this section, even if you and your spouse have already split up your stuff. You should ask for maintenance because your spouse makes so much more money than you do. If you plan to work with our clinics, you don't need to buy the Part 2 paperwork because we provide it for free. That sounds good. Do you want to say anything about her leaving Wisconsin? I hope you get what you're asking for. Don't forget to write in your arrears balances before you submit the form. So take a minute, think about, you can pause the video if you want, take a minute, think about whether each of these is legal advice or legal information, and then we'll hop into our answer key here. So the first one, in a divorce, the summons and petition need to be served on the other party within 90 days. That is legal information. It is true no matter who you are talking to. And that sort of rule of thumb, I tell you, it's true no matter who you're talking to. There can be, so like, for example, if people are filing as joint petitioners, they actually don't need to serve the other person, but that doesn't mean this isn't still legal information, right? It is true for any person who files separately. So it's still information, not advice. Number 2 probably tripped you up. 90 days from the day you filed was June 10th in this case. That is analysis, right? So by calculating that number, I am telling them I'm analyzing their situation. The next person who comes in, if I say 90 days from the day you filed was June 10th, it probably isn't true. So that is technically legal advice. You'll see this is something that's really tricky for us that we kind of have to find ways to work around. We often do this by saying, like, this form is asking for this. If you enter this date on this website and then you ask the website to add 90 days, it gives us this date. But we're not saying that's what it is. We're just saying that's what the website says. But that's one that's really tricky for us in our clinics. Today is August 19th. I think that might fall into that very common sense category, right? Like, that is true no matter who you're talking to, the date. You're toast. That is obviously advice, because while it isn't advice, you're not telling them what to say or do, you are making a prediction about how this is going to go, right? You're toast. This isn't going to work. So that is legal advice. Maybe not super professional legal advice, but legal advice nonetheless. These two here, both I think are pretty clearly, at least the first one, very clearly just information. We can approve this if you have this. Here, everyone has to fill out this section, even if you and your spouse have already split up your stuff. I know some people think it sounds a little bit like advice because here it's saying, even if you have already done this, and often you may be saying this to someone where it is the case that they have already split up their stuff and they're telling you they don't think they should have to do the form because they already split their stuff up. But this would be true no matter who you're talking to. So if you're talking to someone where they have not split their stuff up yet, and you say everyone has to fill out this section, even if you and your spouse have already split up your stuff, that even clause isn't necessarily true for the person you're talking, isn't necessarily the situation of the person you're talking to, but it's still true. Everyone has to fill this out, even if they've already split their stuff up. I think the one on the top right over here was pretty obvious, that saying you should ask for maintenance because your spouse makes so much more money than you do. This is obviously advice, right? You are analyzing that person's situation and advising them on what to do. Next one, again, this is just information. You don't have to buy the paperwork because we provide it for free. That sounds great, or that sounds good. That one's a little tricky because it depends on what it's in response to. There are certainly situations where that sounds good might not be advice, Can you go over to the can you go over to the copy machine? Yeah, that sounds good. I mean, there again could be reasons why it isn't advice, but generally speaking, if you're saying that sounds good, it's often in response to someone saying, "Does that sound okay? Is that an okay thing to put here?" And that sounds good. Again, is giving that implied, yes, that is the right thing to say. And telling someone that's the right thing to say is advice. Do you want to say anything about her leaving Wisconsin? So this is a little bit of a tricky one. I bet a lot of folks thought this was going to be legal advice. Technically, it isn't. It's a question. Do you want to include that piece of information? It is not advice. It is just a question. So that's a way we can kind of sometimes prompt someone to maybe add something that you think they should add, or, that they told you that you think might be relevant, without giving advice, right? Do you want to say anything about that? Do you want to include this? Obviously, if the client says no, bummer, you can't say you really should, man. But that can be a way to sort of gently hint to someone that, maybe they should do this. I hope you get what you're asking for. I know a lot of people think this one feels like advice because it's like you're rooting for them. You want, but this is really just a hope, right? It isn't. It isn't the same as telling them it's going to work, right? It's not saying I think this is going to work. It's just saying I hope it works for you. So that that sort of information is going there. Don't forget to write your arrears balances before you submit the form. Again, that's a reminder. It's just telling them what needs to be done with the form for it to be complete before they turn it in. So that is our little section on legal advice versus legal information. Again, really big things to remember, broad strokes. Legal information is something you would tell anyone in this specific, anyone filing separately for divorce, anyone doing a modification, anyone asking questions about their child support. As long as you would say it to anyone, it is probably procedural information. If you are analyzing their specific situation, it is probably advice. So again, if it wouldn't be true for every single person that you're talking to, probably advice. We're now going to hop into some terminology. There are tons of terms you're going to learn as you're working for us, but these are kind of the ones you need to really hit the ground running. If you remember nothing else of this training, please remember this distinction that I'm about to tell you. So, any of you who have ever had a conversation with another person or watched a movie or a TV show or anything have probably heard the term custody. And when you heard it on that movie or TV show, or when your great Aunt Mabel was telling you about her custody battle, it probably was used to talk about where the child lives or spends time. In Wisconsin, that is not the case. Here in Wisconsin, when we use the term custody, we just mean decision-making power. So legal custody in Wisconsin refers to decision-making power. It's deciding where the child goes to school, deciding who their doctor is, what religion they are, that kind of thing. But it has nothing to do with where the child lives or spends time. Placement is the term that we use here in Wisconsin when we are talking about where the child lives and when they spend time with the parent they don't live with. So again, custody versus placement. Really important to know the distinction here because, like you guys until 2 minutes ago, most of our clients think the term custody talks about where the child lives or spends time. So you're going to have clients who are going to come in and they're going to say, I want full custody. As a lawyer, I hate that term because to me it means nothing, right? It's sole custody is all the decision making. They're not saying that. It doesn't mean anything. But they're going to say, I want full custody, or I want custody of my kid, or I want to talk about custody. And one of the things that it's your job to do is to check with them and say, hey, when you say custody, do you mean decision-making power? Do you mean where the child lives? Or do you mean both of those things? Because we need to make sure that we understand what the client is talking about. I'm not saying that you have to correct them. You don't have to be like, oh, you're saying it wrong. But you do have to make sure that you understand what they want to talk about. Do they want to talk about decision making? Do they want to talk about where the child lives? Or do they want to talk about both? So, custody versus placement. Big thing, make sure you know those definitions. And the other thing I want you to work on is When you're talking to the clients, your main goal is to figure out what they are talking about. But these two terms will be important when you're talking to the supervisors too, right? So when you're talking with a supervisor, you don't want to say they want full custody because that's not going to mean much to us. You either can not use the terms, but explain what they are. So you can say, well, they want to be able to make decisions for their child, or they want their child to live with them. Okay, great. We can work with that. Or you can say, well, they want custody and primary placement, right? So when you're talking to the attorneys, you want to shift your language to be more specific so we can be clear about what the clients are talking about. Child support, I think, is pretty self-explanatory. I think most people know what child support is, but it's something we talk about a lot. It's basically a court-ordered payment that supports or pays for the child's most basic needs: food, clothing, shelter, etc. Another thing that sometimes clients will call child support, but again, this is something where we kind of have to make a distinction, is arrears. So arrears can actually be, in the law, they can be any debt or back amount owed. But for our purposes in our clinic, when we're talking about arrears, we are talking about debts or back amounts owed on child support. And there are two kinds of arrears that we will talk about. Sometimes we'll be talking about the arrears balances. So that's the total amount a person owes. So think of it this way. If I'm supposed to pay $100 a month to my ex in child support, I lose my job for a period of time and I can't make that $100 a month, so I don't pay for 6 months. I owe $600, right? I missed 6 payments of $100 a month. There's also interest, but we won't get into that right now. So I owe $600. That $600 is my arrears balance. There's also arrears payments. So this is how much a person pays each month towards paying off their arrears balances. So again, if we go to my example, I owe my ex $600 a month, I get a new job, and in addition to my $100 of child support, I start paying $25 a month towards my $600 in arrears. That $25 per month is my arrears payment. Last but not least, taxes. Obviously, the word taxes can mean a ton of things, but within the context of our post-judgment forms, it almost always means who gets to claim the child as a dependent on their taxes. So when you get people that come in and they say, well, I want to talk about taxes, that's when it's, do you want to talk about who claims the child on their taxes? Just like post-judgment, divorce has its own terminology as well. When we talk about divorce, we're going to talk a lot about part 1s and part 2s. So I should note that this part 1 and part 2, these are MJC terms. So we use them here at the Milwaukee Justice Center. And we are ubiquitous enough in the courts that if you went to one of like our judges and said the part 2 documents, they'd probably know what you were talking about. But most like lawyers don't use this terminology. So if you go to a random family lawyer and say, I worked on the part 2 documents, they're probably not going to know precisely what you mean by that. But in any case, the part 1 documents, these are the documents used to start a divorce case. They consist of a summons, a petition, a confidential petition addendum. Again, you don't need to remember the specific forms. And then the part 2 is used to get your final hearing date or court date in front of a judge. So in Milwaukee, and Milwaukee is pretty unique in this sense, when you turn in the part 1, you don't actually get a court date. You get a deadline to turn in the part 2 paperwork. The part 2 is longer and more complicated. They're basically the documents about dividing assets, child support, placement, all that kind of stuff. The dismissal date, as I mentioned, is a deadline. So when you turn in part 1, you are given a dismissal date, and that is the deadline to turn in your part 2 documents. One of the things we talk a lot about with clients in both post-judgment and divorce cases, but it comes up more often, I think, in divorce cases, is service. So the clients need to notify the other party, or if there are multiple parties, in the case, basically that the case has started. So in a divorce, you've served them with part 1 to let them know a case has started. Have to serve them again with part 2 to let them know when the first court date will be. Service is incredibly challenging for a lot of our clients, and so this will be something that you'll spend a lot of time talking about. Last but not least, we have non-marital children. So non-marital children are a child who was born to a female party in the case during the marriage, but is not the other spouse's child. So again, if you have two people who are married, the wife has a child, and I'm going to say the husband, but obviously it could be true if you had two wives as well, but the husband is not the child's father. And no court has ever determined paternity. That is what we call a non-marital child. So if your head is spinning and that feels a little wonky, we'll get more into that. But just kind of be aware that that's something lurking around the edges. So in a minute, we'll go on to the next slide. But before we do, I think it is time to give you your fun fact for this video. So your fun fact is that my favorite video game is the Elder Scrolls Skyrim. Again, my favorite video game is the Elder Scrolls Skyrim. All right, so that is fun fact number 2 in this video. Make sure you want to collect all 3 fun facts, and you will send those to me via email once you're done with the training. So continuing on, there is also some terminology that you'll want to know for the forms themselves. There are 3 major parts of the forms that we talk about. The first part is the caption. The caption is the very top of the form, where you're going to provide some basic information about who the parties are, their addresses, the case number, basic idea of what the form is about. There's like a title. There is a signature block. It is the block of lines at the very bottom of a document where the client signs, and includes some basic information like their address, email address, and phone number. There's also something called a notary block. Some forms that we fill out in the clinic do need to be notarized. These will have a block of text associated with them that basically are where the notary signs, and that text will be one of the ways that you'll know a particular form needs to be notarized. So, we've talked a little bit about the terminology you'll need when you're communicating. Let's talk about getting information from clients. So when your client first sits down with you for an interview, you're going to have something called a fact-finding sheet. Usually this is given to you by the shift supervisor when they are assigning the case to you. And this fact-finding sheet is used to guide your conversation with the client and help you gather some needed information to identify potential red flags and that sort of thing. Make sure you're always going to want to fill out the whole thing. Some of you are going to be tempted to, sorry, I'm going to move my cat if you guys can hear that background noise. That is what is happening there. Sorry, cat. Okay. So when you're filling out these fact-finding sheets, you will want to fill out the whole thing. A lot of you are going to be tempted. You're going to say, like, what are you here to do? And the client is going to overwhelm you with information. And you're going to be like, oh my God, I should stop immediately, not fill this out, and check in with the supervisor because I feel overwhelmed. But you want to power through and fill out the whole form, because typically when you come up to me and you say, oh my God, they said all these things, and I'm going to say, great, what's the other party's name? And you're going to say, I don't know that. I'm going to say, what is the child's name? And you're going to say, I don't know that either. And so you want to fill out as much as you can of the document, because it is important for the supervisor to have that information to help you untangle what is going on. The only time you'll want to come up before you filled the whole thing out is if you think you have the wrong form entirely. So again, if we gave you a divorce part 1 fact-finding sheet and the client says, I'm actually here for a name change, come on up, we'll trade that out. But if it is, the client says, well, I'm here to change my order, and then they spew a bunch of complicated facts at you. You know, they say, my ex and I have an order out of New York, and she just moved to Florida, and the child is living with grandma in Puerto Rico, and I just want to figure out how to change my placement. You might like hear that and say, oh my God, there's a lot of stuff going on there. But go ahead and fill out the form, because it does sound like their basic goal is to modify their order. Make sure after you have filled in the fact-finding sheet, you will check in with the supervisor. In the beginning, that's not going to be hard, but as you get more and more knowledgeable, you're going to want to skip that step. But you always want to check in. There are going to be times where there are red flags that we will see or we will know about that you would have no reason to know about. So do that check-in step again, even if you feel confident that you know what you need to be doing. Part of that fact finding and part of your goal in this interviewing piece will be to determine what the client's goal is. And believe it or not, that's not as easy as it sounds. I get a lot of people who hear me say this and they say, yeah, duh, their goal is to fill out a form. Well, yeah, I know that. In fact, a lot of clients, when you say, what brings you here today? What is your goal? They're going to say, I want to fill out this form, and they're going to hand you a form. We want to go deeper than that. We want to understand, what do they think this form will achieve? What do they want to happen with this form? There are a few reasons for that. The first is sometimes people have the wrong form. A lot of times, clients will go up to the child support office upstairs, and child support does a lot of things well, but if you go up there and say, or if I go up there and I say, hi, I'm Kyla, I work downstairs, they're going to give me a modification form. That is their default setting when someone is in their space and they're not quite sure what to do with you. And so they might give a client a modification when the client actually needs a stipulation. Or they might not realize that this particular person needs to start a divorce. So we're still going to want to figure out, what is the client's goal, right? If somebody says, I want to fill out this form, so they show you a modification form, you say, great. That form is used to change your order when you and the other person don't agree. What is it you'd like to change about your order? So we do want to dig just a little bit deeper beyond fill out this form and figure out what their goals are for a form. Almost every single case we see has one of 4 goals. And as I say this on this training, you're like, yeah, that makes perfect sense. When you're sitting down with the clients and they're throwing tons of weird facts at you, it's going to feel like there is no way this situation in front of you fits into one of these 4 situations, but it almost certainly does. So the 4 things that we typically see are, people want to get a divorce or a legal separation. People want to change their name or the name of their child. They want to change an existing order, or they want to enforce an existing order. And again, when you first sit down with people, it's going to seem impossible that those are the only 4 categories. But again, the vast majority of situations fall into one of those 4 categories. A big part of communicating with the clients is active listening. So as part of active listening, you're building rapport with the client. You are making it so they trust you. You're someone who they think can help them. You want to make sure that they feel heard and understood. Even for people we can't help or that we need to refer elsewhere. Often this is the first place in the courthouse they've been where they've gotten to spend more than 30 seconds talking to someone. So it can be helpful for a lot of people, even if they just, feel like you feel their pain and that you kind of understand what they're going through. Active listening can help us get the information that we need to identify the right form and to fill out the form completely. It's a tool that we can use to get that information we want, because sometimes clients are going to give you lots of information that you don't need, or they're going to not want to give information. And so this can be a helpful way to sort of ease some of that information out. And last but not least, when you're listening to the client, we want to make sure we also identify potential problems and red flags. So clients don't always know what is a potential problem in their case. So you want to make sure that you are paying attention for signs of potential problems. In using sort of active listening as a technique, there are lots of different ways to do active listening. I mean, think of active listening is not just that you're hearing someone, but you are engaging with them, right? So one way to show that you've been listening to active listen is to restate or to summarize something. So if I understand it correctly, you are looking to change your child support amount. Okay, there was a lot going on there. I just want to make sure I understand. It sounds like your ex hasn't been taking their placement time, so you would like to ask the court to make it so they don't have set placement days anymore, and that they now pay child support. And you don't have to use terminology in your summarizing. Sometimes if someone is really having a little bit of trouble with the custody or placement, I might say, it sounds to me like you want to be able to be the only person who makes decisions for your child, and you want your child to live with you and not have any time where they see the other parent. Right? That's also a summary as well, even though I didn't use any of the legal terminology. And I guess before I go through all of these are tools, right? So you'll find ones that you like better than others. You'll find in some situations, one tool works better than the other tools. So you don't have to necessarily use all of these, but these are just different tools that you can use. Encouragers, again, just kind of shows you're listening. Okay, and then what happened? All right, I think I've got that. Tell me a little bit more. Yep, okay. I mean, just the little interjections that you kind of plug into your speech that show, I'm listening to you, I want you to keep going. Emotional labeling, I will admit to you, this is a tool that I myself do not use very much. But emotional labeling, it's trying to basically identify that you understand how the client is feeling. So it sounds like you're feeling really frustrated by the fact that your ex won't work with you. It sounds like you just want to be able to be the best parent possible. It sounds like you're feeling sad because you're not able to see your child right now. It sounds like honestly, often frustration is one of the ones we're dealing with. But that can be a way to, again, sort of connect with people and show, I get it. I get how you're feeling. Validation. So validation, that sounds frustrating. I appreciate how difficult that must be. Emotional labeling is a bit more, it sounds like you're feeling blank, whereas validation is not necessarily saying that that is the correct thing to be feeling, but basically, I get how you could be feeling that way. And again, because I have the emotional depth of a teaspoon, these two are not ones I necessarily use a lot myself, but that doesn't mean they aren't ones that you're not going to find useful for you. Sometimes you're going to ask open-ended questions. What would happen if? So what would happen if you brought this form to your ex and asked them to sign it? What would happen if you asked your ex to sign a form? What would happen if your ex got a hold of your address? What would happen if you came in on Thursday instead of Friday? What would happen, where you're just trying to get some information out of people. Last but not least is redirecting. So sometimes you're going to have a client who just really wants to focus on something that is meaningful to them, but is not at all relevant to what you're trying to do. They're going to be going, oh, my ex is so terrible, and let me tell you about this one time they wouldn't even let me go to my kid's birthday. And you're like, right, but we need to be talking about how you want to change your child support. And so what they're talking about is not necessarily relevant. So redirecting, it can be useful to let people talk for a little bit. Sometimes they just need to get it off their chest. They need someone else to understand how hard this process has been for them. But basically, once you get a moment to kind of interject, I get how frustrating that must be for you. Let me ask you a couple of questions so we can get this form filled out and start addressing that. That sounds difficult. Let's go ahead and start working on this form so that we can get, this filled out. Let's focus on this. I know yet, right? So just redirecting, really drawing their attention back to where you need that attention to be. Client interviewing, you can have some nonverbal listening skills as well. You want to make eye contact. That can be a great way to show that you are listening to someone. Mirroring people, again, you don't want it to seem like you are mocking them, but matching posture, sitting up, leaning forward, standing, leaning to one side, leaning forward, backward, having a similar or parallel way that you're acting can sometimes feel to folks like it's a connection. Gestures, again, nodding, smiling, using gestures when you talk. These are things that you probably do without even thinking about it to show that you're listening to someone, right? When one of your friends is telling you a story, you nod and go, yep, right? You smile at them. You kind of go, yeah, you make that expression. Yeah, I hear you. So again, some of these things you're going to do without even thinking about it. You want to avoid distractions as much as possible. From your perspective, I never want to see you on your phone. That's a great way to break your repertoire with your client really quickly, right? So, I mean, obviously, there will be exceptions. There will be that time where your mom calls you 911 and you have to take it for a minute. But basically, you shouldn't be on your phone when you're with a client. The client may sometimes be on their phone. You're going to want to, as much as possible, try and keep their attention on you. But there are going to be times when there are going to be kids or co pilots along with the client. And so it's going to be kind of gently going, okay, just real quick, I need you to focus back in on me. And so that can be something that is challenging. But you want to make sure there aren't distractions on your end so we can better manage the potential distractions coming in from the client's end. A few tips for follow-ups and redirects. I think we've mentioned most of these. Again, if the client tells you they want to fill out a specific form, try explain to them what the form does and then confirm what it is they want the form to do, right? So I used the example of the mod before. The modification is used to change an existing order. Or here it looks like this example actually has me using the stip. So the stipulation form is used to change an order when you and the other party agree. Does the other party agree and would they sign everything? Yep, great. And what is it you guys want to change with this order? So that can be, again, just an easy way to kind of move off that I just want to fill out a form answer. As we already talked about, anytime anyone says, I just want to change custody, you are going to clarify to figure out if they mean custody or placement. And again, if the client really seems like they're off topic, when you get a moment, you can kind of say, that sounds frustrating, or I see why you would want to change your order, or I hear you, let's get this form done, right? And now I need your address so we can fill out this form and you can get what you are looking for. All right, so that is it with client interviewing. I'm sure by this point you guys are going, oh my God, almost 2 hours in, and we haven't even looked at the forms yet. We haven't, but in the next video, we will get into the forms. We will talk generally about some of the forms that are available, and then we're going to actually break it down into a number of shorter videos where we'll go through various parts of the forms process. So I'm looking forward to seeing you guys on the next video for that one.